In this month's news session, a court reform bill proposing major changes to jury trials, appeal rights and the rules governing evidence. A House of Lords report warning that our forensic science system risks becoming a national scandal in the making, and continuing uncertainty surrounding the path to a full re-examination of the Lucy Letby case. At first glance, these may seem like separate stories, but they are not. They all raise the same fundamental question: are we strengthening the accuracy of criminal trials, or are we quietly weakening the safeguards that make them reliable? Because once a conviction is entered, overturning it is extraordinarily difficult. That means the trial itself is everything. So today, we're going to connect the dots and examine what these developments really mean for the future of justice.
Welcome to Spoken in Justice, where we put the criminal justice system in the dock. We could not begin this month's news session without scrutinizing the 25th of February press release proclaiming a so-called landmark bill boldly marketed as delivering faster and fairer justice for victims. David Lammy has chosen to move swiftly on the matter, and it seems that despite significant concerns raised from various quarters, the government is intent on pushing the proposal through and securing its implementation as quickly as possible. First, one point to note is the language used in this press release. One passage in particular should give pause to anyone concerned with the integrity of the justice system. Among the pragmatic reforms included within the new bill is handing the power to judges to decide where cases are heard, ending the ability of criminals to game the system by dragging out proceedings and tormenting their victims. The language is striking. At the stage under discussion, i.e. the determination of venue, the individuals concerned are in law defendants. They are not criminals. Under the presumption of innocence, a foundational principle of any common law system, a person does not become a criminal unless and until a court has convicted them. This distinction is not semantic. It goes to the heart of how justice is understood and administered. The tone is clearly political and emotionally charged, aimed at winning the support of voters. Those who want faster justice are frustrated by perceived technicalities and believe the system favors defendants too much. The passage assumes guilt rhetorically, frames procedural disputes such as venue or case management as bad faith tactics, and suggests that those using existing procedural rights are gaming the system, portraying procedural rights as illegitimate tricks. It is deeply troubling that this reform is being presented to the public through rhetoric designed to tap into an instinctive desire to see criminals punished. It diverts the discussion away from careful reflection on procedural fairness and reframes it instead as a question of punishment and retribution. Reform of the justice system ought to be argued on the strength of its legal principles and practical merits, not promoted by capitalizing on public frustration or by blurring the crucial distinction between accusation and conviction. We have repeatedly addressed this mindset and the role it has already played in creating the current crisis within our criminal justice system. And in fact, it seems appropriate at this stage to pause and look into it in more detail. Much has been said about the importance of retaining juries, about the defendant's right to elect a jury trial, and about the constitutional safeguards that choice provides, particularly as a protection against excessive or abusive state power. Far less attention, however, has been paid to a central question. Why has the Crown Court backlog more than doubled since the pandemic? The press release states, "The Courts and Tribunals Bill sets out a pragmatic reform of the criminal courts and structural changes to the criminal justice system as a result of increasing charges and a much greater volume of complex cases involving more digital evidence." We have touched on issues of court infrastructure and productivity, yet insufficient scrutiny has been given to the deeper structural drivers: overcriminalization, expansive charging practices, and the cumulative effect of cases that arguably should never have reached a Crown Court trial in the first place. These are among the factors that are truly congesting the system. In this video, for example, we touched on joint enterprise prosecutions. We examined how such cases can overwhelm courtrooms and contribute to prison overcrowding, often on the basis of tenuous or highly speculative evidence. The doctrine is frequently deployed as a wide net, sweeping in multiple individuals on little more than association or presence. Dr. Nisha Waller and Terhan Sultan, co-authors of the central research underpinning that analysis, identified 4 urgent themes emerging from their investigation: the excessive and expansive use of prosecutorial charging powers, a growing reliance on inference and assumption rather than concrete evidence, contradictory or vague prosecution claims, judicial warnings to juries concerning potential prosecutorial overreach. Similarly, in our conversation with Vicky Palombo on domestic abuse prosecutions, we explored evidence suggesting that in an understandable effort to avoid the risk of failing victims, police and prosecutors may err on the side of caution by advancing borderline cases. While well-intentioned, this approach can contribute to procedural strain, drawing cases into the system that may ultimately lack evidential robustness. We have also discussed how legislation is sometimes advanced on incomplete or flawed premises. The cumulative impact of these dynamics has not been examined with the depth and candor required. Without confronting the underlying drivers of case inflation, procedural congestion will persist, no matter how many structural reforms are introduced. If the prevailing attitude remains unchanged, if charging decisions continue to expand and safeguards are diluted, the volume of cases will rise, pressures will intensify, and the risk of miscarriages of justice will inevitably grow. If reform is to succeed, it must begin not with the erosion of safeguards, but with an honest appraisal of what is truly overwhelming the system. Now, let's turn to the bill itself. We will focus on part 1, which deals specifically with criminal courts, and there is no surprise here. In simple terms, the bill confirms the proposal would remove a defendant's right to choose to have their case heard in the Crown Court for offences that can currently be tried either in the Magistrates' Court or the Crown Court. So at the moment, if defendants are charged with this type of offence, they can usually choose to be tried by a jury in the Crown Court. Well, under these proposals, that choice would disappear. It would also remove the requirement for a defendant's consent if a case is sent back down from the Crown Court to the Magistrates' Court. In other words, decisions about where a defendant's case is heard would increasingly be taken out of defendants' hands. The bill also changes how appeals work. Right now, if someone is convicted in the Magistrates' Court, they have an automatic right to appeal to the Crown Court, where the case is reheard from the beginning. Well, the proposal would replace that automatic right with a permission stage, meaning you would first need approval to appeal, and instead of a full rehearing, the appeal would only focus on specific issues that have been approved. That's a significant narrowing of the safety net. Another major change involves sentencing powers. Magistrates will be given the ability to impose longer prison sentences, up to 18 months or even 24 months for certain offences. The idea is to keep more cases in the Magistrates' Court and reduce pressure on the Crown Court. On paper, that may sound efficient, but it also means more serious cases with longer possible prison sentence being decided in lower courts without juries. And the bill also proposes creating a new section of the Crown Court called the Bench Division, where certain cases that might result in a sentence of 3 years or less would be decided by a judge sitting alone without a jury. In addition, complex or lengthy fraud and financial crime cases could also be tried by a judge alone. Taken together, these proposals represent a clear move away from jury trials in a wider range of cases. We've said it before, jury trial has long been seen as a safeguard, a way of ensuring that ordinary members of the public, not just state officials, decide guilt. Moving more cases to judge-only trials changes that balance. The bill also includes changes to the rules about what evidence can be used in court, particularly in sexual offence cases, drawing on recommendations from the Law Commission. Reviewing evidence rules isn't wrong in itself. The system should evolve if there are real problems, but the way these changes are being presented matters. Again, the language used in the press materials talks about preventing the misuse of evidence to unfairly undermine victims. The difficulty here is timing. Before a court has decided what happened, the legal system works on the basis that an allegation is just that, an allegation. The purpose of a trial is to determine whether a crime was committed and by whom. Referring to someone as a victim before that decision has been made risks blurring the line between accusation and proof. The presumption of innocence depends on that line being clear. Substantively, the bill aims to tighten the rules about when evidence relating to a complainant's previous allegations, compensation claims, or sexual history can be raised. These areas are already heavily restricted because they involve two competing concerns: protecting people from intrusive or unfair questioning and ensuring that someone accused of a crime can properly challenge the case against them. If the rules are tightened too much, relevant information may be kept from the court. If they are too loose, questioning can become unfair or prejudicial. The challenge is balance, and that balance is delicate. The proposals would also expand and clarify special measures such as giving evidence behind screens or by video link to make them easier to access. That may help people feel more able to give evidence. But again, these measures are meant to help witnesses communicate clearly, not to disadvantage the defense. And that balance is important. Another important change concerns previous domestic abuse convictions. The bill would make it clear the past convictions can be used to show a tendency or propensity to commit similar offences. That is a significant step. Traditionally, the law has been cautious about using someone's past to prove their present guilt because there is a real risk that a jury might think they've done it before, so they probably did it again, rather than focusing strictly on the evidence in the current case. Safeguards exist for a reason: to ensure each charge is judged on its own facts. When you look at all these changes together, they are not just minor technical adjustments. They reflect a broader shift in priorities, moving cases more quickly through the system, reducing the role of juries, tightening appeal rights, and adjusting evidence rules, all in the name of efficiency. I hope this has helped to cut through the noise and lay out plainly and honestly what this bill really represents. Because this is not a minor procedural tweak. It asks us to step away from safeguards that have stood for centuries. Protections built slowly, carefully, and often in response of hard-learned lessons about the dangers of unchecked state power. Before we dismantle rights that generations fought to secure, we should be certain, absolutely certain, that the evidence justifies it. That the problem has been properly diagnosed. That the cure will not be worse than the disease. The question is not whether reform is needed. It is whether we have been shown clear, reliable, and compelling proof that abandoning long-established protections is the only answer. When we move away from principles that have anchored our justice system for hundreds of years, we are not just adjusting procedures. We are redefining the balance between the individual and the state. And that is not something that should ever be done lightly. Turning now to another deeply troubling issue, one that poses a real and growing risk of miscarriages of justice, we come to the collapsing state of our forensic science system. Members of the House of Lords have warned that this is fast becoming a national scandal. We have previously reported on the House of Lords Science and Technology Committee and its follow-up inquiry into forensic science. Now, on the 17th of February, the committee published a stark report titled Rebuilding Forensic Science for Criminal Justice, an Urgent Need. Its conclusions are alarming. The report describes a system in crisis. The commercial forensic market is fragile and close to being monopolized, meaning that if one major provider fails, the entire system could be thrown into chaos. In-house forensic services run by police forces are inconsistent and lack proper oversight. Meanwhile, the backlog in digital forensics, phones, laptops, and other devices waiting to be examined exceeds 20,000 devices and has barely improved in recent years. Lord Mayor, chair of the committee, warned that as the forensic science system continues to atrophy, despite repeated warnings, creeping neglect is beginning to resemble a shocking abdication of responsibility by the government and is a national scandal in the making. If this decline is allowed to continue, further miscarriages of justice are inevitable. The committee's central recommendation is the creation this year of a National Institute for Forensic Science. This body would oversee standards, promote research and development, protect specialist skills that are in danger of disappearing, and crucially, safeguard the independence of forensic evidence from investigative pressures. The report makes several recommendations. The government should urgently assess the risks created by the near monopoly in the forensic market, stabilize current provision, make it easier for new providers to enter the field, and ensure that police contracts pay a fair and substantial price. Any new national forensic service must operate independently from the police. The committee points to the Scottish model, where a sterile corridor separates forensic analysis from police investigations to preserve impartiality. The responsibility for long-term evidence storage should be removed from police forces and placed with an independent national body. The Ministry of Justice should review legal aid rates for defense forensic experts so that those challenging prosecution evidence are properly funded. A credible plan must be put in place to preserve specialist disciplines such as fiber and footprint analysis, which are currently a risk of disappearing altogether. Digital forensics is an area of particular concern. The scale of backlog continues to delay justice for both complainants and defendants. At the same time, new threats are emerging, including deepfake material that current forensic tools may struggle to detect. The committee recommends a focused program of research and development to create trusted AI and digital tools capable of tackling both the backlog and the authenticity challenges of modern evidence. Forensic science is often described as the silent witness in a courtroom. It can secure convictions and can also prevent wrongful ones. When that system weakens, The risk is not abstract. It translates into unreliable evidence, delayed trials, lost expertise, and ultimately unsafe verdicts. If the justice system is already under strain, the deterioration of forensic science does not merely add pressure, it strikes at the very reliability of the evidence upon which verdicts depend. And finally, we close our news session turning to a case we have followed very closely, the case of Lucy Letby. We will simply note the latest formal developments, one update from the Criminal Cases Review Commission and another from the Thirlwall Inquiry. Starting with the CCRC, on the 13th of February, it issued a public announcement setting out a timeline of the material it has received so far. The statement is largely factual and speaks for itself. The key point, however, is clear. The Commission does not appear to be anywhere near reaching a decision. Relevant material is being submitted in stages, and further documentation was still being provided as recently as January 2026. That alone indicates the scale and complexity of the review. The CCRC must consider all of that evidence in full before forming a view, and this is evidently a substantial and intricate task. That said, we welcome the fact that the CCRC has made a public statement. It represents a positive step towards greater transparency and openness, and it helps to keep the public informed about where the process stands. Turning to the forthcoming report from the Thirlwall Inquiry, a further announcement was made on the 27th of February. Like the CCRC update, it is a factual statement that largely speaks for itself. It states that drafting on the report is very well advanced. One point that may be worth noting, however, is a slight shift in timing. In November, it was indicated that the report was expected to be published after Easter 2026. This more recent announcement now states that a further update will be provided after Easter. That wording may suggest that publication is not as imminent as previously anticipated. That said, it is important not to read too much into this, and speculation at this stage will not be helpful. And of course, the inquests into the deaths of the babies for which Letby was convicted were opened, as we know, and adjourned on the 4th of February and are due to resume between 14th and 25th of September this year. Lucy Letby has been granted interested person status in those inquests. So the road toward a proper and thorough re-examination of this case is uncertain, complex, and likely to be a lengthy one. The central takeaway from our analysis of this case is one we have emphasized before. It underlines just how vital it is to get a trial right in the first place. Once a conviction has been secured, the process of challenging and overturning it is extraordinarily complex. It is not simply a matter of raising doubts or presenting alternative interpretations. The legal thresholds are high, the procedural hurdles are significant, and the time involved can stretch into years. Fresh evidence must meet strict criteria. Review bodies must sift through vast quantities of material. Courts must be persuaded that that conviction is not just questionable, but legally unsafe. The system is designed to favor finality, and undoing that finality is neither simple nor swift. That reality should sharpen our focus at the earlier stage, the trial itself. The trial is the primary forum where evidence is tested, experts are examined, and arguments are scrutinized in real time. It is where safeguards matter most, where disclosure must be thorough, expert evidence must be reliable, and the defense must have a full and fair opportunity to challenge the prosecution's case. If errors occur at that stage, whether due to incomplete disclosure, difficult decision about what evidence is allowed or excluded, unreliable expert testimony, procedural imbalances, or wider systemic pressures, putting them right later becomes vastly more challenging. Appeals and review bodies are not substitutes for a properly conducted trial. They are safety nets, and safety nets are not designed to replace the foundations. So the lesson is clear. The criminal justice system should prioritize accuracy at the front end. It should invest through investigation, robust evidential standards, independent expertise, and procedural fairness at trial. Because once a verdict is delivered, the path to undoing it is long, uncertain, and often plainly slow. We have discussed three very different developments: the Court Reform Bill, the deeply concerning findings of the Forensic Science Inquiry, and the latest updates in the Lucy Letby case. At first glance, they may seem like separate stories, but they are not. They are connected by a single fundamental theme: the importance of getting a trial right the first time. The Lucy Letby case, whatever view one takes of it, demonstrates something structural about our system. Once a conviction has been entered, overturning is extraordinarily difficult. If correcting errors later is so complex, then accuracy at trial is not simply desirable, it is essential. And yet, at the same time, we are considering reforms that reduce jury involvement, narrow appeal rights, and expand the use of certain types of evidence. We are also facing a forensic science system that has been described by members of the House of Lords as fragile, near monopolized, and in urgent need of rebuilding. A trial depends on strong foundations, reliable evidence, independent expertise, meaningful safeguards, and a fair balance between the individual and the state. If those foundations weaken, the consequences do not disappear once a verdict is delivered. They become harder to detect and even harder to undo. Justice is not measured by how quickly a case moves through the system. It is measured by how safely and reliably it reaches its conclusion. A criminal trial is not an administrative step. It is the moment at which the power of the state controls the liberty of the individual. That moment demands care and rigor. It demands that we preserve safeguards unless we are absolutely certain they are no longer needed. Because history teaches us something simple: when safeguards are reduced in the name of efficiency, the risk of irreversible error increases. And once a conviction is secured, reversing that error is one of the hardest tasks our legal system faces. I hope you found this week's video interesting. Our aim is to connect developments that may seem unrelated at first glance and show how, when viewed together, they reveal a much bigger picture about the direction of our justice system. If you found this analysis helpful, please consider liking the video, subscribing to this channel, and sharing it with others who may also be interested. And as always, I'd really value hearing your thoughts, so leave your views in the comments below. Join us again as we sit and rise in this unique trial.